2020-1024, State of New Mexico versus Vivian Nguyen.
Daniela Tamarova on behalf of the state.
Osama M. Rashid, appearing on behalf of Ms. Nguyen, who is present, Your Honor.
Thank you, and...
Your Honor, based on the court's inquiry, I think it's best if we just go ahead and proceed.
Sure.
And deal with the breath test evidence and resolve this case. My client is scheduled to, he's in the military.
Okay.
He's scheduled to go to Bahrain in July. So
Okay.
it's like if we were to delay the balance of this case or anything like that, she would probably not be able to get the first offender program done by the time she has to leave in the event that she... So I think
Okay.
it's best if we just go ahead and proceed.
Sure, sure, okay. And, State, are you calling Deputy Hammerl back to the stand?
Yes, Your Honor.
Okay.
I'll go back.
Okay, okay, and that's fine. Deputy Hammerl, you're still under oath. I put you under oath earlier, and you're still under oath. So if you can just remember that and make yourself comfortable, please.
Thank you, Your Honor. Deputy, we're just going to kind of start where we left off.
Okay.
So we left off at the arrest. What happened after that?
I had Vivian face my vehicle, and I checked her mouth with flashlight and made sure that there weren't any foreign substances in it, and documented the time, notated it at 0:32 hours.
Why did you document the time?
It's the start of the minimum 20-minute deprivation period to keep them from having any food, drink, substances in their mouth to contaminate a possible breath sample in the future.
Any chemical tests offered or administered to the defendant?
Yes.
What was that?
It was a breath test at the Prisoner Transport Center downtown.
What kind of machine is used to administer this test?
The Intoxilizer 8000, or as we abbreviate, the IR 8000.
Are you trained or certified to operate the IR 8000?
Yes, I am trained to certify it at the basic level, or to use it at a basic level, and I'm a key operator. So I'm responsible for the, basically the courier for it to take it to SLD and perform proficiencies quarterly on the machine.
Certified on July 10th, 2020?
Yes.
Before this date, when had you operated this machine?
Before that date, when had I operated it? Several times before that date.
Roughly how many times?
I mean, probably approaching 1,000 times or so.
How did you communicate the implied consent advisory to the defendant?
It's posted on a poster on the wall right next to the machine itself, which is how I read it to Vivian as she sat next to the machine.
Did she appear to understand the implied consent advisory?
Yes, she replied appropriately to the questions asked.
In reading the implied consent advisory, was she advised of her rights to an independent test?
She was, because it was read verbatim, which includes that portion.
Was she advised that the arresting agency would have then paid for that independent test?
Yes, she was.
Did the defendant agree to take a breath test?
She did. She stated yes, that she would take it.
How is breath alcohol content measured by the Intoxilizer 8000?
Grams of alcohol per 210 liters of breath.
Was the Intoxilizer 8000 that you used on the date certified by the Scientific Laboratory Division?
It was. It has a placard on the front of it that has the issue and expiration date from SLD affixed to the front of the machine, which on this date would have been 9/30 of 2020, I believe was the date here, yeah.
So did you check the date on
Yes.
the machine? And was the defendant's date of her test within that range?
Yes.
What was the first thing you did after turning on the Intoxilizer 8000?
The machine runs through a diagnostic test, also does air blanks to ensure no contaminants inside the tube, and a brand new mouthpiece was taken and removed from the plastic sealed wrapping and affixed to the machine itself.
So did the machine run this diagnostic check on that date?
It did,
And did the machine pass the diagnostic check?
yes,
Did the machine run a calibration check?
it did.
And was the calibration check within the regulation?
Yes, it was within the .07 to .09 range.
So did the machine appear to be working properly?
It did appear to be working properly, and I didn't see any discrepancies in the logbook.
How would you know if the machine is not working properly?
The machine will error out and give you an error code for whatever may be causing an issue with the machine, and then it will not allow you to submit a sample.
Was the defendant given a clean mouthpiece?
Yes,
Did you instruct the defendant on how to properly give a breath sample?
I did.
What is an air blank that the machine runs?
It runs air through the tube itself and the mouthpiece, since it's affixed to it, to ensure that there's no contaminants inside the tube area of the machine, which wraps around the top.
The machine run the required air blanks during the defendant's test?
It did, and it ran it at zeros, which means there's no contaminants.
And I know you've already briefly mentioned this, but what steps did you take to ensure that the defendant did not have anything in her mouth that might have interfered with the test?
Prior to departing the traffic stop, that's when I checked her mouth and notated the time at 0:32. And she remained in my presence and custody for the duration of that deprivation period, which ended at the first breath sample taken.
Serve the defendant for that required 20-minute period?
Yes.
What is the purpose of the 20-minute deprivation period?
To ensure that any mouth alcohol or contaminants would dissipate or have been removed at the start when we checked it, so that there's no error in the sample given.
Smoke or eat or put anything in her mouth during that time?
No, she did not. And prior to giving the actual sample itself, I asked her if she had thrown up in her mouth or consumed any drink or tobacco, gum, anything like that before I checked, and she stated she had not, or before she submitted a sample, excuse me.
How did you time the deprivation period?
On my watch,
What time does the deprivation period begin?
0:32 hours.
And what time did you end the deprivation period?
At the very first breath sample, which was printed out on the breath card itself.
Based on your training and experience with the intoxilizer, was there any evidence of malfunction or error?
No.
Successfully collect the required 2 samples from the defendant? When were these samples obtained?
They were obtained after a 20-minute deprivation period in my presence at the PTC.
How long was it from when you stopped her, or rather from when you arrested her, to when the breath samples were obtained?
I don't know the exact time. It's documented on the breath card itself and in the report, but I don't recall off the top of my head.
And was a record of these test results made?
Yes.
Deputy, I'm showing you what's been marked for identification purposes as State's Exhibit 2. Do you recognize it?
Yes.
Without saying the results, what is this?
This is the copied version of the printed breath card.
What is the date on this breath card?
It would be July 10th, 2020.
Who is the test subject?
Vivian Nguyen.
Is there a signature on this card?
There is. It is mine,
How do you know it's your signature?
because that's my signature.
Is it in the same or similar condition as when the test was performed?
Yes.
Have the results been altered in any way?
No.
Your Honor, at this time, the state would like to admit the breath card results into evidence.
Defense?
Not tendered certification. However, there is a certification document that would be necessary and required under the circumstances. The state hasn't tendered the certificate to court that indicates that SLD certification. The gas canister also has to be certified under State versus Hall. They haven't established that. They haven't. Established, and so we would object to the admission of the breath test.
Okay, state?
Your Honor, the certification of the machine is not required. The officer's testimony that the machine was certified, that he was certified to operate this machine on this date, that it ran all of its checks, it was calibrated properly and was working properly, is all that is required for the foundational basis for this breath card.
State, defense? Anything more for the record? Okay, and, the state has satisfied the foundational requirements for the breath test. And I'm finding that that foundation has been met. So your motion is denied, Mr. Rashid. Okay, and did you get a chance to look at the breath card that the state has? Okay, and so over defense's objection, the court will allow the breath card to be entered as state's exhibit number 2.
Deputy, are these the results that were obtained from the defendant on July 10th, 2020?
They are.
What are the results?
The first result was subject test at 00:57 hour, concluding the 20-minute deprivation period, and that would have been at 0.12 grams of alcohol per 210 liters of breath, followed by a calibration check of 0.80 grams of alcohol per 210 liters of breath, showing the machine within calibration, followed by a second sample and a final sample of 0.11 grams of alcohol per 210 liters of breath at 01:01 hours.
And, Deputy, I'm going to ask a question that I had previously asked. What was the amount of time between when you pulled the defendant over when she was driving and when the breath tests were taken, the last test?
So the start of the traffic stop was at 0:15 hours. The conclusion of the breath test was 0:57, but the 20-minute deprivation period started at 00:32 and concluded at 0:57 in excess of 20 minutes.
Sure.
And I have no further questions.
Defense?
Your Honor, if I may bring up.
Yes, please. Yeah. And any other questions for Deputy Hammerl?
No, Your Honor, the
Oh.
state rests.
Okay. And defense didn't have a cross-examination? Any other further cross? Okay, okay. And so at this time, can we excuse Deputy Hammerl? Defense? Okay. Deputy, thank you. You're welcome to stay or leave. I think maybe wait in the hallway during, defense, I don't know if you have a motion for directed verdict at this point?
Court will grant it, but I'll make the motion for a directed verdict of acquittal. I think that the court should grant a directed verdict on the issue of impairment to the slightest degree. I don't think that the state has established beyond a reasonable doubt that, or a reasonable jury could at this point find that my client was impaired by alcohol based on the evidence prior to the breath test. So we believe that if the court is going to convict, the court should only convict on the per se basis for the breath test being admitted and that breath score being illegal based on the manner and timing that it was submitted. So we believe that the court should not find any proof beyond a reasonable doubt with reference to, or that a reasonable jury could not find at this point that my client was impaired by alcohol, although obviously the breath test would result in a per se.
State.
Light most favorable to the state has met the burden of proving the charges of DWI. I'm not even going to go through the impaired to the slightest. I'm going to focus on the per se. For you to find the defendant guilty, the court must find that the defendant operated a motor vehicle within 3 hours of driving, that she had an alcohol concentration of 8/100 or grams or more per 100 liters of breath, and that this happened in Bernalillo County, in the city of Albuquerque, in the state of New Mexico, on or about the 10th day of July, 2020. Your Honor, looking at Deputy Hammerall's testimony and the lapel video, which showed what he testified to, that while speaking to the defendant, she admitted to drinking. She told the deputy exactly how many drinks she had and when. She told him where she drove from, the fact that she was, she had 1 drink at one bar, 2 drinks at the other bar. And even though she told the deputy that her last drink was at 7:22 p.m., Your Honor, the statute requires that the concentration of blood alcohol content be within 3 hours of driving, not that she was drinking within 3 hours of the breath test. And in this case, State's Exhibit 2, as admitted, the breath test shows that it was taken around, the first sample around 12:55 a.m., the second one a little bit after 1 a.m., and the deputy pulled her over around 12:15 a.m., meaning that that was about an hour between the driving and the breath test. The breath test results of 0.12 and 0.11 are above the 0.08 legal limit. So within the 3 hours of driving, her BAC was still above the limit, and Deputy Hammerall told us exactly where this happened, that it was within the city of Albuquerque, the county of Bernalillo, and the state of New Mexico. And as we saw in the lapel video, she was driving, so all 3 elements of the statute have been satisfied. And for these reasons, Your Honor, the state has met the burden of proving these charges, and we ask that you deny defense counsel's motion.
Defense. Sure. Okay, and parties, I am finding that there is sufficient evidence to go to the next standard. The state has proven, in the light most favorable to the state, that there is sufficient evidence to move forward with the charge. Okay. And defense doesn't wish to put on a case? Okay. Okay, I'll hear final argument, starting with the state.
Said for directed verdict.
I'm sorry?
May I incorporate what I've just said all for directed verdict?
Of course.
I would just like to add a few things. First, when the deputy first came into contact with the defendant, he said he immediately smelled the odor of alcohol. He said that there were bloodshot, watery eyes. Then, when we turned to the standardized field sobriety test, as he testified, there were 4 clues in the walk and turn test. There was 1 clue in the one leg stand. And so, based on the totality of all those circumstances, the officer found that, the defendant was probably drinking and driving in his reasonable opinion. And at that point, he decided that the best course of action would be to bring her to the prisoner transport center and complete the BAC, the breath alcohol test. He testified that the machine was working properly, everything was running properly, every check was completed, every step was taken, the proper deprivation period was taken, that she was given a clean new mouthpiece, explained how to use it, the implied consent act was read, so every step was followed properly. And at that point, when she did complete the breath test to which she agreed, the results were at or above the 0.08 limit. They were at 0.12, 0.11, and that was, as the statute requires, within 3 hours of driving. So the deputy, to the first part of the statute, saw her operate a motor vehicle. He watched it happen. We watched it on video. The breath test was given within 3 hours of that driving and was above 0.08 grams in 210 liters of breath. And as I had just mentioned, it was in the city of Albuquerque, county of Bernalillo, state of New Mexico. Your Honor, those are the elements of a crime that the state has proven beyond a reasonable doubt. that on July 10th, 2020, the defendant did commit the crime as charged of driving while under the influence of intoxicating liquor or drugs, and we therefore ask that the state, or I apologize, that the court find the defendant guilty of the charge of DWI. Thank you, Your Honor.
Same point, but now we're at the reasonable doubt stage. We're not at directed, not at probable cause, we're not at the law, which is proof beyond a reasonable doubt. The court should have a reasonable doubt as to my client's level of impairment and whether that rose to the sufficient level to justify a conviction for DWI. The court can look at all the things that she did right in terms of immediate response, immediately pulling over, not striking a curb or anything like that, immediately producing documents, having no problems with her exit, having no problems in her interaction with the officer, her ability to keep her foot up the entire time on the one-leg stand, the minor issues that she had on the walk and turn, especially given the fact that the officer didn't even count half of it. So under the circumstances, we don't believe that the state has proven impaired to the slightest degree under that component of the standard. Obviously, the court's admitted the breath test. It's a .12, .11. If you believe it, you have to convict on the per se, but I believe that it should only be a conviction on the per se and not based on impairment to the slightest degree. Under that standard, we would ask the court to find her not guilty of DWI under impaired to the slightest degree, and obviously, if the court believes the breath test, you're going to rule with that. So,
State.
I would just mention that the state is not proceeding on impaired to the slightest, and we are proceeding on the per se.
Okay, thank you. And parties, I don't need to take any more time. I think I looked at the video quite a bit as well as my notes when I went to review for probable cause. And so now we're at the higher standard of beyond a reasonable doubt. And again, I have to rely on Deputy Hammerl's training and experience and his observations on the night of the incident, observing the driving from Miss Nguyen, using her signals improperly, following a vehicle too closely. Let me get my other notes that I had. Bloodshot, watery eyes, the odor of alcohol, admitting to drinking alcohol, and the performance on the heel-to-toe test, observing 4 clues. I know defense argues that Deputy Hammer only did half of the test, but the court does have to note that there were significant clues on the part that the first 9 steps that Ms. Nguyen took when Deputy Hammerl was focused on her performance. So taking that into consideration, as well as now the breath test, that I believe the state did lay a proper foundation for the breath test. There were no indications that the machine was not working properly. The officer was certified. Sorry, I think I did something there. Okay, the officer was certified to operate the intoxilizer. The dates of the certification were within range. The machine was working properly, ran air blanks, did the diagnostic check. The calibration was within the range as well of .07 to .09. Clean mouthpiece was used, and there were no discrepancies in the machine. No error codes came up when Deputy Hammerl was using the machine. He said that he also checked the logbook to make sure there were no errors or no issues with the machine before he ran the test for Ms. Nguyen. So the court is relying on the Intoxilizer 8000, that it was working properly, that it gave an accurate breath test of .12 and .11, which are above the .08 per se violation for DWI. So for those reasons, I am finding Ms. Nguyen guilty of a DWI first offense under the per se standard, that her breath score was above a .08, and both the scores were above a .08. So that's my ruling. We can proceed to sentencing now if you'd like. Okay. Ms. Nguyen, you do have 15 days to appeal my ruling, and Mr. Rashid can discuss that with you further if you'd like to do that. Are there any recommendations as to sentencing, Ms. Kamarova?
She's actively in the military. She is eligible for veterans court.
Is this a true first offense?
Yes.
Okay, so she's also eligible for the first offender program, correct? Okay. I don't know, have you all discussed, I mean, I don't know that she'd be eligible for veterans court. There's another track, right? That's for first, because it's usually 2 or more, right?
Specifically for first.
Okay. Okay, so, Mr. Rashid, did you want to? Sure, let me hear from you.
So, reference to Veterans Court. I think Veterans Court can have some benefits for people who are active military, especially if they've been deployed, dealt with PTSD, had, physical disabilities, mental disabilities that resulted from their military service, and that the concept is that they would identify better with somebody from the military, and that's why that track works. Bottom line for me is, on a first offense, if a person is sentenced under the first offender program, they have to do the screening, the DWI school, victim impact panel, the 24 hours of community service, ignition interlock for a year, and interlock license for a year, and pay court costs of approximately $380. If she does Veterans Court, she still has to do every one of those things. And the only thing Veterans Court would do would be have her do more things, not less, not make it easier on her, not make it more helpful to her. Just a circumstance where Veterans Court and the goals and objectives of Veterans Court and my client don't fit together. And so under the circumstances, the court should sentence her to the standard first offender program, defer sentencing. We're going to ask the court, especially given this case is almost 2 years old and my client hasn't been rearrested for anything in between. She had one speeding ticket that we submitted to the court and notified the court of and the state of, and no action was taken. We believe that she's an ideal candidate for the first offender program. We'd ask that you sentence her accordingly, give her a deferred sentence. I'm going to ask that it be a 6-month deferred instead of a year. This court has jurisdiction to go down as low as 90 days. But my goal is, and I already mentioned to the court, that the military is going to be sending her to Bahrain, what appears to be July 28th of 22. So she needs to get in the first offender program and out of the first offender program as quickly as possible to avoid there being a big problem with her getting deployed in the middle of, she still has one DWI school class left and they deploy her, that's a problem. So we believe that standard, regular first offender program is appropriate, but we would ask that the court consider a shorter probationary period. We would also ask that the court consider waiving probation costs under the circumstances, given that she is in the military and is about to be deployed. So that would be the appropriate sentence, and we would ask the court to avoid any of the veteran court programs or anything that would be more than you have to do under the circumstances. And I know that she's been compliant with her conditions. I've met with her numerous times throughout the course of this case. I never had one question about her sobriety or whether she was taking care of business or doing the right thing or the wrong thing. Model client, she has been a helpful client, she's been an attentive client, she's been a concerned client, and she cared about her case and cared about the outcome. So she'll be fine, Judge. You're not going to see her again. And so we, would request the court just do the first.
State regarding the request for a 6-month deferred sentence?
Your Honor, because it's her first offense, I have no opposition to that.
Okay, okay, and with the state's agreement, Ms. Nguyen, having been found guilty of a DWI first offense, the sentence will be deferred for a period of 6 months on the condition that you serve 6 months of supervised probation and that you complete the following. So we're gonna go over this, just give me one moment. You have 6 months of supervised probation. The sentence will be deferred for 6 months on the condition that you complete the following. You must attend and complete DWI school. You must complete the drug and alcohol abuse screening here in Metro Court and any recommendations or requirements for counseling and treatment. You must attend the victim impact panel. All 3 of those first things are available online, and my clerk can give you the information about those. You cannot possess or consume alcohol or illegal drugs or cannabis unless you have a medical cannabis card and you provide proof of that to the court. You may be randomly tested for drugs and alcohol. You must obtain the ignition interlock license and have the device installed on any vehicle that you drive for a period of 1 year per the statute. Have you had the ignition interlock yet, Ms. Nguyen? Okay, so I can't give you credit at this time. You also must complete 24 hours of community service. You cannot violate any federal, state, or local criminal laws while you're on probation. And there are mandatory court costs and fees that you must pay. Was there any jail credit, Mr. Rashid? Okay, state any objection to giving her 1-day jail credit?
Your Honor.
Okay, I'll make a note that 1-day jail credit will go towards court costs and fees that are mandatory. And regarding probation costs, state, there was a request to waive probation costs.
No objection, Your Honor.
Okay, I will waive probation costs. And Ms. Nguyen, probably one of the things you want to take care of right away too is the 24 hours community service. It might, depending on the agencies, and it might be hard to get into an agency where you can get them all done, but I kind of don't know how those are going right now. But a lot of people are asking for extensions to get that done. So anything else, parties?
Your Honor, nothing else from the state.
Okay, and I am also authorizing an ROR appeal bond in case defense wants to appeal.
Ask the court to indicate that, she does have the 15 days to determine, wants to appeal before she has to check in with.
Okay, and Ms. Nguyen, you do have 15 days to make the decision whether or not you want to appeal. And it would be an ROR appeal bond, although I think you might have, I don't know how they do it downstairs. If they wait for after the 15 days, or if they expect you to call in and do an intake, and then if the...
Can order that she doesn't have to do anything until, like, at 15 days, she either has to appeal or check in with probation is the way.
Okay, I'll make a note. I'll make a note on the order, and defendant is not required to check in with probation until the 15 days has passed. Okay. Thank you, parties. Ms. Nguyen, my clerk will call you up and give you all of your paperwork. And good luck to you. Okay, thank you. I'm just gonna see what our afternoon looks like. Did we have clearances that I need to look at?